In this video, I would like to talk about the appointment of judges. In fact, this is a very important aspect, how judges are appointed, and it became very controversial, and so many things have happened. The law was changed, constitutional amendment took place, it has been declared unconstitutional, many things have happened. So, it is a very important discussion, and it is all about, it is closely linked to the independence of judiciary, and that is where the questions were there also. And let us see what are the constitutional provision and what is the present status of appointment of judges. So, the topic is appointment of judges, appointment of judges, and what are the constitutional provisions, and now what is the present status. Okay. So, Article 124 2 of the Constitution says every judge of the Supreme Court shall be appointed by the President of India. So, who will appoint? So, judges are appointed by the President of India. So, President of India can appoint the judges, and but after consultation with the such of the judges of the Supreme Court. Now, very clearly says President of India can appoint after consultation. After consultation with such number of judges of the Supreme Court and of the High Courts in the states. So, after consultation with such number of judges of Supreme Court as well as the High Courts, of Supreme Court and High Courts, as the President may deem necessary. Because President has the choice with how many judges he want to consult, as the President may deem necessary, as the President may deem necessary. So, President has a choice to consult, and he can consult with more judges, he can consult with lesser number of judges, but he has to consult, and he shall be holding the office. And a judge, so a judge will be appointed by the President of India after consultation with such number of judges of the Supreme Court and the High Courts as the judge, as the President may deem necessary, and such judges will hold the office till he or she attains the age of 65. Can hold, and the judges can hold the office till they attain 65 years of age. So, Article 124(2) is very clear that the judges are appointed by the President of India. So, no doubt regarding this, are appointed by the President of India, but after consultation. You have to consult. See, the literal meaning of consultation is you have to discuss with the judges, but after consultation the opinion of the President of India will be final. Okay. So, the meaning, what was understood right from the beginning, what is the meaning of it? The meaning is the President will appoint. President will appoint. The final authority is with the President, but when we say President, please do not confuse. The President is ably aided and advised by the Council of Ministers. So, ultimately it is the decision of the Council of Ministers. So, the literal meaning, the final conclusion what we can make from Article 124(2) is the Council of Ministers have the final say. Final say. So, the executive have the final say. The executive decides on the appointment of the, so the executives appoint the judiciary, and that is the the grand design of our constitution makers. See, the constitution makers wanted the checks and balances. I always talk about the checks and balances. So, we wanted the checks and the balances, and how do you balance it? The executive appoint the judiciary, executive appoints the judges. Then who can remove? I will be coming to that. The next article is on that only. The parliament can remove. Parliament has the power to remove the judges. The parliament can remove the judges. Of course, the procedure is through the parliament. Of course, the President of India will sign, I know that, but parliament has the power to recommend the removal of the judges. The parliament has the power to remove, and the judiciary has this power of judicial review. Judiciary can strike down any action, so judiciary has the judicial review. They can strike down any law passed by the parliament, and they can strike down any action. They can declare any action of the executive unconstitutional, can declare any action of the executive or any law passed by the parliament, unconstitutional. So the judiciary has the judicial review. So you see, it's a triangle now. So the judiciary, the executive, the legislature. The judiciary, the executive appoints the judiciary, the judges. The legislature remove the judges. But the judiciary can declare any law or any action of the executive unconstitutional. That is how the checks and balances in the Indian Constitution. So Article 124 is very clear. It is the duty of the executive, it is the duty of the Prime Minister, it is the duty of the Council of Ministers to recommend a name to the President, and President of India will be appointing a judge. So the full control of the appointment of the judges are in the hands of the executive according to Article 124(2). So Article 124(2) is very clear. It is the executive, it is the Prime Minister, and in fact finally it is the President of India will appoint on behalf of the Prime Minister the elected representative. That is how the appointment system. So this was challenged in the court. Now what happened subsequently, let us see. So in the first 30 years there is no doubt regarding this. Now in 1980, a very famous case called the SP Gupta case. In SP Gupta case, this issue was challenged regarding the consultation, the word consultation. So because after consultation with such number of judges as the President may consider necessary, as he may deem necessary. So the question was about the word consultation, and the verdict in the SP Gupta case, the verdict by the Supreme Court was that the consultation is not binding on the President. Consultation is not binding on the President. Meaning, the President of India should consult, but that does not mean that whatever opinion given by the judges are not final. He has to only consult. Consultation is not binding on the President, but the consultation should be effective. That is what in the SP Gupta case the Supreme Court gave the verdict. Supreme Court said that yes, consultation is a must, but whatever opinion given by the judges are not binding. It is not necessary that the President of India should accept that opinion. What do you mean by effective consultation? Consultation should be effective. What is effective consultation? Supreme Court clarified that. Supreme Court said that all material facts about the proposed person, the person who is supposed to be appointed, you pass on or you hand over all the facts about the person whose name is considered to be given to the judges. So the effective consultation means all material facts available about the proposed candidate to be handed over to the judges. Okay, the judges with whom the President of India is consulting, the President should hand over all material facts related to that person, the proposed candidate, to the judges, so that the judges can give an effective opinion. So the consultation should be effective. All material facts available with the President should be given to the judges, so that the judges can give an opinion about that concerned person or the proposed candidate. So, but the President's decision is final. So 1980 verdict, very clear, it once again upheld the power of the executive to appoint. The verdict, the final conclusion of the 1980 verdict is the executive has the authority to appoint judges. No doubt regarding this. So who will decide? Executive will decide, but executive should consult, only consult, and the opinion of the judges are not final. So that was the situation in 1980. Then the same issue was challenged once again in the Supreme Court in 1993. This is called the Supreme Court Advocates on Record Association versus Union of India case. The Supreme Court Advocates on Record Association. Versus Union of India case. Union of India case 1993. So Supreme Court Advocates on Record Association versus Union of India case. See now, as I was mentioning about the Keshwan Bharati case also, please remember, it's all many a times it's political. The judges also behave according to the political climate. See, in 1980 also Supreme Court said that, and in fact I will say, and especially from the Keshwan Bharati case onwards, most of the time, the judges, most of the judgments were really great judgments. There are exceptions. We have seen that ADM Jabalpur case and all, where the judges approved and said that there is no right to life during emergency and all, but there are exceptions. But generally, by and large, Supreme Court upheld the constitution and they interpret the constitution in the right manner. But by 1990s, please remember, there is a politically, 1990s India was quite weak. Please remember, Indira Gandhi was assassinated in 1984. Rajiv Gandhi was assassinated in early 1990s. And there as a coalition government came to power, or a minority government under P.V. Narasimha Rao came to power, our economy was in deep trouble. And there was no consistency in the political parties also. Too many political parties, mandalization took place, and a lot of division in the society. Then the Babri Masjid demolition took place. So communally we were divided, caste-wise we were divided because of the Mandal Commission agitation and things like that. So it was a very, very volatile situation in India, and the political executives were not that strong. P.V. Narasimha Rao was not considered to be a very strong leader, but definitely he was a very shrewd leader, very smart leader, but he was not considered to be a very strong or a muscle power leader. Definitely he was not that kind of a person. So, and economy was in deep trouble. Judges, struck. This is where I always tell, the three organs of the government, three organs, like we have the executive, we have the legislature, we have the judiciary, and it cannot be equal always, depending upon the personality. Now today we know it's all powerful PMO and the Prime Minister, and no discussion. Even every organ in this country has succumbed to the pressure. During Indira Gandhi's time, it was almost like that. But during Nehru's time, Jawaharlal Nehru's time, it was all powerful parliament. Parliament was supreme. Then Indira Gandhi and Rajiv Gandhi's time, it was, and even now Prime Minister Modi's time, it's all powerful executive. But during 90s and the first decade of the present century, or rather till 2014, I will say it was the turn of the judiciary, because of the weak political executives. So judiciary struck in 1993. and through this Advocates on Record Association case. And the same question came back to judiciary once again regarding the word consultation. Regarding consultation in Article 124(2), the same question came, and the Supreme Court this time reversed its earlier verdict and declared that the consultation is binding. Consultation is binding. That was a complete U-turn from what was said in the S.P. Gupta case. In S.P. Gupta case, Supreme Court said that consultation is not binding, and the opinion, now it is very clear that the opinion of the Chief Justice of India is final. The opinion of the Chief Justice of India is final. And the Supreme Court also said that the power to initiate the appointment of judges will be with the Chief Justice of India. The Chief Justice of India will initiate the process of appointment of judges. So, this is a complete U-turn, complete change. See, till 1993, executives appointed, the judges were consulted. Now, in 1993, when there is a weak executive, when there is a weak political system in our country because of various factors, the judges took over and said that we will decide. Our opinion is final. The Chief Justice of India's opinion is final. Chief Justice of India will initiate the process. And this was the beginning of the collegium system in India. Collegium system in India in the appointment of the judges. In the appointment of the judges. So, the collegium system took over from the executive. So, that was in 1993, and the political executive did not do anything. They did not have the majority also. See, they could have amended the constitution and declared that it is the duty of the executive to appoint, but they could not do because P.V. Narasimha Rao government was a minority government. They did not have enough parliamentary support at that time, and it was a fragile government. Economy was weak, politically we were weak, caste wise we were completely divided, communally we were divided, so much of communal tension in India that there were riots going on across the country. So, it was a very, very bad phase of our country during 1990s. Judges took over the responsibility of appointment of the judges. So, this was, it is not challenged in the Supreme Court because the political executive did not have the guts to go and challenge it. Instead, through the advisory jurisdiction, okay, what when the subsequent NDA government came to power in 1998, the the executive through the advisory jurisdiction of the Supreme Court, advisory jurisdiction, through the advisory jurisdiction, the President of India made a reference, a special reference to the Supreme Court. So, President made a special reference to the judiciary, meaning special reference to the Supreme Court. Meaning, the President of India asked for some clarification, asked for some advice regarding the appointment of the judges. So, basically in 1998, the President of India sought the advice of the judiciary under the advisory jurisdiction of the Supreme Court. I will be talking about advisory jurisdiction separately. So, it invoked that particular provision of the Constitution where the the President of India asked for an advice, how exactly we should go about in the appointment of the judges. So, they did not challenge the judgment. Instead, they asked for an advice from the Supreme Court. That itself shows how weak the executives were there at that time because of the lack of majority in the parliament. So, in this advisory jurisdiction of 1998, Supreme Court clarified. Okay, in this, Supreme Court laid down the procedure of the collegium system. Supreme Court laid down the procedure of the collegium system to be followed, and Supreme Court said, number one, the opinion of CJI is final. There is no doubt regarding this. Consultation is binding. Consultation is binding. Number 3, the Supreme Court Chief Justice or Chief Justice of India will initiate the appointment process. Okay, the Chief Justice of India will initiate the appointment process. Number 4, CJI will consult 4 senior most judges. Now, the Supreme Court made it very clear that how many judges CJI will consult. They are trying to give a democratic, some sort of democracy to bring in. So, see, now the collegium or other, it is very in the advisory jurisdiction. Supreme Court says that CJI will consult 4 senior most judges. So, 5 senior most judges will take the CJI plus 4. So, the CJI plus 4 judges, the senior most judges will be the collegium. So, that is what the in 1998 Supreme Court said, these 4 plus 1 CJI put together 5 judges will give the opinion, and it also said that CJI will convey the opinion of all the 5 judges, opinion of all the 5 in the collegium to the President. Okay. Now, it is not that all 5 will be having the same opinion. So, the majority opinion will be final. If 3 judges agree on a particular person's name, that will be final. So, natural, because that is in the democracy, that is how it will be happening. So, the collegium will convey the opinion of all the 5 judges, but CJI will consult the 4 senior most judges before giving his opinion. And then it also said that if the President of India has any objection, if the President has any objection on any name proposed by the CJI, if the President of India has any objection on any name proposed by the CJI, President can send back the advice or send back the advice to the CJI. The President can send back the advice. So, the advice given by the Chief Justice will be returned back to the Chief Justice. The CJI will consult. Now, again, and the next point is the CJI and the collegium will reconsider. Okay, the CJI and the collegium will reconsider the advice. So, they will reconsider the advice, but the reconsidered view of CJI and the collegium is final. The reconsidered view of the collegium is final. Okay, the reconsidered view is final. There is no opinion, there is no second opinion. The President will have to appoint that person if the reconsidered view is to appoint the person again. See, the first, please remember the sequence. The sequence is first stage is CJI plus collegium recommended the name of, say, X. Now, the President of India has objection to this name because according to President of India's feedback, this person is not suitable. The President is sending back the advice saying that this person has so and so problem. The CJI and the collegium once again studied about this man, and CJI decided to overrule the objection given by the President of India. So, the reconsidered view of the CJI and the collegium is final. So, in effect, now what is the bottom line? The conclusion. Conclusion is, in effect, the judiciary took over the responsibility, took over the responsibility of the appointment of the judges. See, and there is, please understand, there is no provision for judiciary to appoint judges. The constitutional provision is the president should consult the judges, that's all. Consultation is not binding. That was the understanding in the Constituent Assembly. That is what we understood right from the beginning. Even in the SP Gupta case, Supreme Court declared that the consultation is not binding. But now, from 1993, and then subsequently in the presidential reference case in 1998, Supreme Court made it crystal clear that judiciary will decide. The opinion of the Chief Justice and the 4 senior most judges, what we call it as collegium today, is final, and the president has no choice other than appointing. The only thing they can do is, only thing the president can do is, president can delay the process. President may be able to use his pocket veto. That is the only thing he can do. Otherwise, there is no choice. This is what the Supreme Court has done. So, Supreme Court has effectively taken over, or they have usurped this power. The power to appoint the judges, which was in the hands of the executive, has been literally taken over. It has been hijacked or literally taken over by the judiciary through the 1993 verdict, and subsequently it has reinformed in the 1998 presidential reference case. So, naturally, this was a big blow to the executive. I will say it was a blow to the executive, to the Prime Minister. And because of this reason, in the year 2001 itself, when the NDA government, when Atal Bihari Vajpayee government is still continuing, the then law minister at that time, Arun Jaitley, he recommended, or rather a bill was introduced in the parliament at that time to create a national judicial appointment commission. A bill was introduced, and in that National Judicial Appointment Commission, and they said instead of executive alone appointing the judiciary, or the judges themselves appointing the judiciary, it suggested a commission which is to be headed by the Chief Justice of India, 3 judges plus 2 executives should form this commission. That was the recommendation, or that was the bill introduced in 2001. A bill was introduced, but this bill was never passed in the parliament. So, this National Judicial Appointment Commission bill lapsed after the Vajpayee government lost power. Subsequently, the UPA also introduced a similar bill. UPA also introduced a bill, I think in 2011. But again, they also failed to pass it because they did not have the required majority. Finally, when the new NDA government came to power under Prime Minister Modi, the NDA government immediately introduced, in 2014 itself, they have introduced this National Judicial Appointment Commission bill. Okay, so, see right now, the collegium is holding the power to appoint the judges, and the Prime Minister Modi, when he came to power in 2014, he introduced the National Judicial Appointment Commission bill, and it ultimately managed to pass the 99th Amendment Act. 2014 National Judicial Appointments Commission, National Judicial Appointments Commission, or NJAC bill was passed, or the 99th Amendment Act was passed, and that was in August 2014. August 2014. And please remember, this is immediately after the Prime Minister Modi came to power. It was in May he came to power. June, July, August, within 2.5 months, this was passed. And at the time, please remember, this bill was passed almost unanimously. Almost unanimously. In the parliament, all the opposition parties, including the Congress party, all the opposition parties supported this bill. It is almost a unanimous, almost, I am not saying it is unanimous, almost a unanimous law, and since it involved in the change in the appointment of the judiciary and all, it affects the federal system, it was sent to the state legislative assemblies. We will be talking about that. Some of the constitutional amendments you can do only after it is approved by 50% of the state legislative assemblies. So, 16 state legislative assemblies also passed it. So, in August 2014, the constitutional amendment was passed, and this bill was ratified by 16 state legislative assemblies, and the President of India at that time, Mr. Pranab Mukherjee, the President Pranab Mukherjee, in December 2014 ascended, and this NJAC came into force in December 2014. NJAC came into force. The National Judicial Appointments Commission came into force, and this, of course, this was challenged in the Supreme Court immediately, no doubt regarding this. And according to this NJAC, according to this 99th Amendment Act, I will come to the verdict of the Supreme Court later on, but let me talk about some of the provisions of the 99th Amendment Act. Some of the provisions of the 99th, it gave constitutional status. So, first of all, constitutional status to NJAC, National Judicial Appointments Commission, and this NJAC will replace the collegium system, and it will replace the collegium system. It will replace the collegium system, and the collegium, according to this provision, the collegium will be headed by the Chief Justice of India plus 2 senior most judges, plus the law minister, plus 2 eminent citizens nominated to the collegium, nominated to the NJAC, 2 eminent citizens nominated to the NJAC. So, there will be 6 members. See, there is a big change from what was the NJAC proposed in 2001 and what is there today. In 2001, it was said that 3 judges plus 2 executives. Now, it is said that 3 judges plus 3 executives, meaning law minister and 2 eminent citizens, senior most, there will be a union law minister and 2 eminent persons. And these 2 eminent persons will be selected, or it will be nominated by a committee. These 2 eminent persons will be selected by a committee comprising of Prime Minister, Chief Justice of India plus Leader of Opposition. Leader of Opposition in the Lok Sabha. So, it is decided that these 2 eminent persons are to be selected by a committee comprising of Prime Minister, Chief Justice of India and the Leader of Opposition in the Lok Sabha, and one of the eminent persons to be nominated should belong to scheduled caste, scheduled tribe, OBC, minority or women. That is what all of them clubbed together. One of the eminent persons should be belonging to a scheduled caste, scheduled tribe or OBC or minority or women. That is also provided. And this was this was given. This is given about the National Judicial Appointment Commission was given in Article 124A. Article 124A deals with the commission and who all will be the members of the commission, 6-member commission, CJI will be heading it. Everything was mentioned in Article 124A. Then it also added 124B. Article 124B was added, that talked about the functions of the commission. Functions of the commission. Article 124B dealt with the functions of the commission. It said that this commission will appoint all the judges of the Supreme Court, judges of Supreme Court, then judges of High Court, and it will also recommend the transfer of the High Court judges, all the three. It said that the judges of the Supreme Court will be there, the appointment of the judges of the High Court, as well as the transfer of High Court judges. So, they made it very clear that these are the functions of these National Judicial Appointment Commission, Article 124B. Then it also created another article called Article 124C. Article 124C, it talked about the power of the Parliament to make law regarding the appointment of the Chief Justice, etc. The Parliament can make law. Parliament can make law regarding the appointment of the judges of the Supreme Court, High Court, etc. Regarding the appointment of judges of Supreme Court, High Court, etc. So, these three articles were inserted through the 99th Amendment Act, and this 99th Amendment Act was challenged in the Supreme Court, and within a few months, in October 2015, now in October 2015, Supreme Court in a 4-1 verdict declared that NJAC is unconstitutional. That means what? Supreme Court declared that whatever amendment you have made, whatever articles you have introduced, Article 124A, 124B, 124C, all these articles are unconstitutional. And Supreme Court said that this is a violation of the basic structure of the Constitution. It affects the independence of judiciary. This constitutional amendment affects the independence of judiciary. It affects the independence of judiciary. And please remember, what happened was that the day the President signed it, and it became, the NJC has become an act. 99th Amendment Act was approved or signed by the President of India. Within a few days, it was challenged in the Supreme Court. Supreme Court stayed the functioning of NJAC. NJAC was never constituted. It could not appoint even a single judge. Within 10 months, October 2015, see, on 31st of December 2014, the President of India signed, and Constitutional Amendment Act, 99th Amendment Act came into force. NJAC was created, or at the provision for NJAC, the constitutional amendment took place, but NJAC was never convened. The Supreme Court struck it down in October 2015 and rejected the concept of National Appointments Commission. That means, once again, collegium system is in force. Once again, collegium system is valid. Supreme Court declared that judiciary cannot risk being caught in a web of indebtedness towards the government. Supreme Court said that if this NJAC came into force, the judiciary will be indebted to the government. Judiciary will be indebted to the government. The independence of judiciary will be affected, and Supreme Court said that the politicians and the civil society cannot have a final say in the appointment of the judges. Supreme Court said it will be difficult to hold the wisdom of the appointment of the judges to be shared with the political executive. We cannot share the wisdom of appointment of judges with the political executive. Supreme Court also said that the judiciary, the expectation from the judiciary to safeguard the rights of the citizens of this country can be ensured. The judiciary can safeguard the rights of the citizens only if it is absolutely insulated and independent from the other organs of the government. So, Supreme Court declared that the judges should be absolutely insulated, absolutely insulated and independent. The judges should be absolutely insulated and independent from the other organs of the governance. From the other organs of governance. So, the judges should be absolutely insulated and independent from the other organs of the governance, and the bench clearly said that this NJS is unconstitutional and void, and it also said that this collegium system has also its own drawbacks, but the best option right now is collegium system, even though it has some drawbacks. But NJS is unacceptable. It will, it will interfere. It will interfere in the independence of judiciary. See, now why judges have given such a verdict? Even though appointing judges have its own drawback because it's not mentioned in the constitution. But what I would like to say, there is a political reason. The political reason is very simple. When Prime Minister Modi came to power in May 2014, and this verdict is in October 2015, more than 1 year has elapsed. And slowly, one by one, the whole country could see that he is holding, or he is tightening his grip over each and every organ of the government, each and every independent institution. And even by this time, people started talking about Prime Minister Modi continuing to be in power, or other till 2029 and things like that. People were saying there is no doubt regarding his re-election, and it has happened also, we have seen it. Even in 2024, people are saying, at that time itself, in 15 itself, people started talking and saying that there is no contest for Prime Minister Modi. The way, even today, you can realize the way, he has, subdued the judiciary already. He has subdued all the organs, the election commission, all independent organs. We can see how they are functioning today. The judges could sense it in 2015 itself, what is going to come in future. So, those judges, those 5 judges who gave the verdict, they were fully clear that what is in store for judiciary in the future. That is why they said that no question of giving any hold for the executive in the appointment of the judges. And they were frightened by the prospects of executive overwhelming and controlling everything that they could foresee, and they were seeing it now the way the judiciary is functioning. Even after having no National Judicial Appointment Commission, even after having this collegium system continuing, the way the judiciary has succumbed to pressure, the way judiciary has got silenced themselves in most of the cases, that shows that the judiciary, those 5 judges, even though it is a 4-1 judgment, even that one judge, Justice Chalameshwar, he was a very upright judge. His only objection was the collegium system is also not foolproof. He never said that the appointment commission, see, he was talking about an appointment commission only because even there are problems in the collegium system. But he had no doubt regarding the need for independence of the judiciary. So, whatever it is, the judges got frightened by the way in which Prime Minister Modi started controlling various organs of the government and various independent institutions, the way he started controlling the media. The judges could sense what is in store. So, finally, coming to the present situation. So, what is the present situation? Present situation is very simple. The 1993 verdict and the 1998 presidential reference verdict is final. Appointment of the judges are done by the collegium, or rather by the president, but after a recommendation by the collegium, and the consultation or the opinion given by the collegium is final. So, judges are still appointing the judges, but even in that, the twist of the matter is the judiciary is slowly getting succumbed to the pressure, and they are also and now by 2020 we can see how many of these judgments are coming and how the judiciary is behaving. That is a separate story, but as of today, Article 124(2) talking about the appointment of the judges, the consultation is binding, and CJI and 4 senior most judges opinion, the collegium system is still continuing and their opinion is final. So even though it is not the right thing, even though it is not the best thing to happen, but definitely considering the hold, the strong iron grip of the executive over the judiciary also today, this is the last hope for India, or last hope for democracy to survive in India. That is the only thing I would like to say here. So this is about the appointment of judges. So it has gone through various phases. Earlier, executive decided everything, then judiciary decided everything, and in between for a brief period, 5-6 months, National Judicial Appointment Commission came, where both executive and judiciary will decide on the appointment, but once again back to collegium system and judiciary decides everything on the appointment. So that is the situation. So this may not be the best system, but in the given option, this is the last hope for us. That is the final comment I would like to make about this collegium system.